There are certain questions that just, well, they keep coming up, don't they? Questions about leaders, especially when you're trying to figure out the why behind certain decisions.
Absolutely. And for many Nigerians, questions about President Tinubu's background and his administration's policies, they definitely fall into that category. There's a real desire to understand more deeply.
Yeah, a need for clarity.
Yeah.
And that's exactly what we're digging into today. There's been a pretty significant development over in the U.S.
Ah, the court order.
That's the one. A U.S. court has ordered the release of investigation files, dossier, connected to President Bola Tinubu, specifically from the 1990s.
Which could potentially shed some light on those longstanding allegations we've heard about.
Precisely. It feels like this could cut through some of the speculation.
Yeah.
So for this deep dive, we're looking mainly at a news report that details this court order and the whole legal backstory. And our mission, if you like, is just to unpack what happened in this legal case and what these developments might tell us about those, persistent questions surrounding President Tinubu's history and, frankly, his eligibility.
Got it. A deep dive into the facts as presented in the report.
Exactly. So, okay, the report starts with the core news. The United States District Court for the District of Columbia, that's Judge Beryl Howell, ordered U.S. law enforcement agencies to release information.
Specifically the FBI and the DEA.
Yes, the FBI and DEA release confidential information on President Tinubu from what the report calls a purported federal investigation in the 1990s.
And the judge's reasoning was quite striking, wasn't it?
It really was. Judge Howell said protecting this information was, and I'm quoting here, neither logical nor plausible. That's pretty direct language from a judge.
It certainly suggests the arguments for keeping it under wraps weren't holding up anymore, that the ground had shifted.
Yeah. And this whole thing spins out of a Freedom of Information Act lawsuit, a FOIA lawsuit.
Right, FOIA, the mechanism for citizens to request government records.
Exactly. And this suit was filed by a guy named Aaron Greenspan back in June 2023. He went after quite a few agencies.
Let's see, the report mentioned the U.S. Attorney's Office, State Department, FBI, IRS, DEA, even the CIA.
That's right. And his claim was basically that these agencies weren't playing ball. They hadn't released documents related to these supposed investigations into President Tinubu and another person, Abiodun Agbele, within the time frame the law requires.
So he's essentially accusing them of stonewalling, or at least dragging their feet on releasing potentially important information.
Seems like it. And the report says he was persistent. Between 2022 and 2023, he fired off 12 separate FOIA requests to those 6 agencies.
12 requests. Okay, so he was really pushing for this. What exactly was he looking for?
He was after information about a joint investigation. FBI, IRS, DEA, and the U.S. Attorney's offices in northern Indiana and northern Illinois.
And the focus of that investigation.
According to his request, it was about charging decisions related to a Chicago heroin ring back in the early 1990s, including potential money laundering aspects.
Heroin trafficking, money laundering, these are obviously very serious allegations.
No kidding. And Greenspan wasn't vague. He named 4 specific individuals in his requests, claiming they were allegedly associated with the drug ring.
Okay, who were they?
Bola Tinubu, Lee Andrew Edwards, Muiza Begboyega Akande, and Abiodun Agbele.
So he had specific targets for these records requests, linking them to this alleged operation.
Right. Now, things got legally interesting pretty quickly. Initially, all 5 agencies involved, not the CIA initially, but the others gave what's called a GLOMAR response.
Ah, the GLOMAR. The classic, we can neither confirm nor deny the existence of records.
Exactly. It's basically a wall. They use it when even saying, yes, we have files, could reveal too much, maybe about intelligence or ongoing work.
So the fact that multiple agencies went with GLOMAR suggests they viewed this as highly sensitive right from the start.
Definitely. But Greenspan didn't just accept that. He appealed these GLOMAR responses to the Department of Justice's Office of Information Policy, the OIP.
And how did they go?
The OIP actually backed the agencies. They upheld the refusal to confirm or deny. So round 1 went to the agencies, you could say.
But he didn't give up.
Nope. That's when he filed the lawsuit, June 2023. Initially against the FBI, DEA, IRS, EOESA, and state, and then later added the CIA to the mix.
Okay, so he took it to federal court.
He did. And he even tried to speed things up. In October 2023, he filed an emergency motion.
An emergency motion, why?
His timing was linked to the Nigerian Supreme Court. They were hearing challenges to President Tinubu's 2023 election victory. Greenspan argued these U.S. records could be relevant to those proceedings in Nigeria.
I see the logic. Information about Tinubu's past potentially impacting the legitimacy arguments being made in the Nigerian courts.
Right. But the U.S. court denied that emergency motion, said it didn't meet the bar for immediate release. Now, around this same time, President Tinubu himself actually got involved in the U.S. case. He filed to intervene.
Intervene? How so?
He cited his privacy interests. He argued that his confidential tax records and documents from law enforcement shouldn't be released under the Privacy Act or FOIA exemptions.
So the president himself stepped in to try and block the release of these specific records. That's quite a move.
It definitely underscores how sensitive he or his legal team considered this information to be.
You know, this inevitably brings up that other piece of history, the one the report mentions too.
The 1993 forfeiture.
Exactly. The $460,000 that Mr. Tinubu forfeited to the U.S. government. Authorities back then linked it to narcotics trafficking proceeds.
Yeah, that's been a recurring theme in discussions about his past, hasn't it? It's a documented event.
It absolutely has. And as the report notes, this exact issue, the forfeiture, was brought up during the presidential election petition court hearings in Nigeria.
Right. His opponents argued it should disqualify him, but the Nigerian court didn't agree ultimately. They affirmed his election.
Correct. So the Nigerian legal system addressed the election challenge based on their laws and the evidence presented there. This U.S. case is separate, focusing on U.S. FOIA law and access to U.S. agency records.
Two different tracks. Okay, so let's get back to Judge Howell's ruling in the U.S. case. She ruled partly for Greenspan, right?
Yes. Specifically regarding the FBI and DEA, she said their glomorph responses, the can't confirm or deny stance, were improper and must be lifted.
Why improper now? What changed?
Judge Howell essentially, the cat was already out of the bag to some extent because it's been publicly acknowledged, like through the 1993 forfeiture case documents, that Tinubu was investigated by agencies, including the FBI and DEA back then.
So the justification for pretending they couldn't even confirm an investigation existed was gone because it was already known?
Pretty much.
Yeah.
The judge explained there are basically two ways to beat a glomar response under FOIA. One, show that confirming or denying won't actually cause the harm the agency fears.
Yeah.
Two, show the agency has already officially acknowledged the information exists. And Greenspan apparently succeeded on that second point regarding the FBI and DEA. He pointed to prior acknowledgments of investigations involving both Agbeya and Tinubu and argued the public interest outweighed privacy concerns now.
Got it. But not for the CIA.
Correct. The report says Greenspan argued the CIA had also acknowledged records, but the judge didn't buy that argument. So the CIA's glomar response holds for now. They don't have to say anything yet.
Okay, so the immediate focus shifts to the FBI and DEA. What are they going to have to reveal?
Well, that's the next stage. The report clarifies that while some of Greenspan's broader requests are still being argued over, the judge has narrowed the current issue down to those glomar responses and any redactions or withheld information specifically about Tinubu and Agbeya.
So it's getting more focused.
Exactly. The court is zeroing in on what these two agencies have on these two individuals and whether it should be released under FOIA.
And there is a deadline looming.
Yes. Judge Howell ordered the remaining parties, everyone except the CIA, to file a joint status report by May 2nd. That report should lay out what issues are still in dispute.
May 2nd. Okay, so that's a date to watch. It should give us a better idea of what might come out and when.
Definitely a key date in this process.
Now, the report also dives into some specifics from way back in 1993, from a Department of Justice complaint.
Right. Documents Greenspan submitted in his case. A verified complaint and an affidavit filed by the DOJ in Illinois, July 1993.
This gives us a glimpse into the investigation at the time, doesn't it?
It really does. This DOJ complaint was aimed at seizing funds civil forfeiture from First Heritage bank accounts linked to Mr. Tinubu. The allegation was these funds were tied to drug trafficking.
And there was an affidavit from an IRS special agent, Kevin Moss.
Yes. Agent Moss's affidavit laid out the details. It described the alleged drug activities of Abiodun Agbeya, and that was used as the basis to go after Tinubu's funds. It even mentions Agbeya being arrested for selling white heroin to an undercover officer.
So the IRS agent is drawing a line from Agbeya's alleged drug dealing to the money in Tinubu's accounts.
Precisely. The argument was that the money was likely proceeds from those illicit sales.
The affidavit also apparently mentioned connections between the individuals. Agbeya supposedly told investigators that Muiz Akande, another name linked to Tinubu in the requests, was his uncle.
Right, and that Akande had set him up with an apartment in Indiana. So it suggests relationships and a potential network operating within the U.S.
It paints a picture, and the details get quite specific about the drug dealing.
Yeah. The affidavit reportedly mentioned DEA intelligence about Egbele selling heroin multiple times, and then a controlled buy set up using an informant source A, which led directly to Egbele's arrest.
A controlled purchase. That shows a pretty active investigation was underway.
Absolutely.
Hmm.
It suggests law enforcement felt they had solid leads and were building a case.
And after the arrest, the affidavit says Egbele agreed to cooperate with the investigation.
That's what the report indicates, the affidavit stated. It also mentioned a lease application he completed being part of the evidence. Cooperation could mean he provided information, potentially about others involved, or the money trail.
Potentially. But the really crucial part of that affidavit, according to the report,
Is that it explicitly confirmed that the FBI and DEA were investigating Tinubu himself as part of this larger probe into Egbele and the alleged drug trafficking.
right, that seems to directly counter any ambiguity about whether Tinubu was officially a subject of investigation back then.
It's a sworn statement from a federal agent involved in the case saying, yes, Tinubu was being investigated in this context.
And the language was strong. The affidavit apparently stated, quote, "There is probable cause to believe that funds in certain bank accounts controlled by Bola Tinubu were involved in financial transactions, violating U.S. law, and represent proceeds of drug trafficking."
Probable cause. That's a specific legal standard indicating a reasonable basis for belief based on the evidence gathered. It's the core justification for seeking the forfeiture.
And it wasn't just one agency's opinion. The affidavit clarified this was based on information from IRS, DEA, and FBI agents working on the case, specifically focused on money laundering of the proceeds of a heroin distribution organization.
So a coordinated multi-agency investigation targeting the financial side of this alleged heroin ring with Tinubu's funds identified as potentially being part of that illicit flow.
Okay, so wrapping this all up, the main takeaway seems pretty clear.
A U.S. court has cracked open the door. It's ordered the FBI and DEA to move past the can't confirm or deny stage regarding these 1990s investigation files on President Tinubu.
Yeah, that Glomar wall has been partially breached, at least for those two agencies. And given everything we've just discussed, the old forfeiture case, the details in that 1993 affidavit, this feels like a potentially significant moment.
It really does,
Yeah.
especially with the ongoing questions in Nigeria about the president's past and, looking ahead towards the 2027 elections. This kind of court-ordered transparency in the U.S. could certainly fuel more discussion and demands for clarity back home.
Definitely. Which leads to a final thought, really. We've seen details emerge from that 1993 complaint, and now we know more information from the FBI and DEA is supposed to be forthcoming. How might all this reshape the understanding, the narratives surrounding President Tinubu?
That's the million-dollar question, isn't it? Could it offer new perspectives? Could it confirm old suspicions for some, or perhaps complicate the picture for others? And what impact might that have on the political landscape in Nigeria as things move forward?
Yeah, definitely something to think about. We hope this deep dive has given everyone listening some valuable context on these latest developments.